Hello, my name is Tiffany Chevron, and I am an attorney with Michel and Associates. I have the distinct pleasure of talking today with Chuck Michel about recent Supreme Court nomination hearings of Judge Amy Coney Barrett and what this means for gun owners in California. Welcome, Chuck.
Thanks for having me. Pleasure to be with you.
Great. Well, before we get started, there are a lot of new gun owners in California, and some have even estimated as many as 1 million new gun owners since the beginning of 2020. So I want to give them a brief background on who you are, Chuck, because some people may not know who you are right now. So Chuck Michel is a senior partner at Michel and Associates. He's also the volunteer president of the California Rifle and Pistol Association, and the author of the California Gun Laws book, which is now in its 8th edition of keeping gun owners in California updated on changing laws in the state, which seems to happen annually. Mr. Michel has been an advocate for over 2 decades in defending civil and constitutional rights, and in particular, he has been and is instrumental in crafting many of the important Second Amendment legal challenges of laws that would infringe upon our constitutional rights. So we are very fortunate to have him to talk to us about these important issues today. So CRPA wanted us to discuss some of the first impressions of the Supreme Court nominee hearing for Judge Amy Coney Barrett this week. And as you know, the Supreme Court nomination hearings for her have just concluded this week. This is the second recent hearing to fill vacancies on the Supreme Court that we've seen just in the past couple of years. And we know that judges are not allowed to answer many of the questions that are posed in these hearings because they can't comment really on cases in which they may rule on later or that are matters of law. So I would just like to know, what are your general thoughts on how the hearings were handled this week and how they went?
Well, obviously the Democrats are, and the liberal progressive side of the Senate and of the gun ban lobby are terrified of her because they know that she will change the balance of the Supreme Court and the way that the Supreme Court approaches analysis of cases and challenges, cases in general and challenges to gun control laws in particular. So they did everything they could to try and throw things at her to disqualify her, but nothing stuck. You know, when the LA Times calls a Supreme Court candidate poised, you know that she did very well, and she did do very well. She artfully declined to answer some questions that it would be inappropriate for her to answer, and she was not rattled. She did not take the bait on some of the ridiculous things that the Democrats on that committee tried to do in order to get her to say something they could use. And so I think it's a foregone conclusion at this point that she'll be on the court, and that's what they were afraid of.
Yeah, I love the picture of her holding up the empty notepad where she answered all of the questions with no notes. That's impressive. So I noticed that the question of the Second Amendment was brought up fairly quickly as well. And Judge Barrett has noted that one of her most significant rulings is a case named Cantor v. Barr, which dealt with nonviolent felon who had lost their Second Amendment rights due to the felony conviction. And Judge Barrett argued in this case that the loss of constitutional rights should only be done under compelling government purposes and for the least restrictive manner to meet those purposes. And in her view, that nonviolent felons losing their rights did not meet the standard for that public safety concern. So why are cases like this significant for constitutional jurisprudence and specifically for the Second Amendment?
Well, okay, so we need a little background and context. I need to set this up a little bit so that the viewers can understand. We got decisions in 2008 in the Heller v. District of Columbia case, and then in 2010 in the McDonald versus City of Chicago case. The Heller case confirmed that the Second Amendment protects a fundamental individual right, not some collective right of states to form a militia. And the McDonald case confirmed that the Second Amendment is incorporated through the 14th Amendment so that infringements by state or local governments are also constitutionally protected and prohibited. So in that context, since 2010, everyone has known that the next question that the Supreme Court really needs to answer, or that needed to be answered by the lower courts, was what's the appropriate standard of review. What that means is when you file a challenge to a gun control law, what level of scrutiny, what degree of critical analysis does a court do? How do they approach whether or not a gun law is constitutional or unconstitutional? And there's been several approaches taken since then, none of which we believe got it right. They've basically pushed the lower courts who don't, especially in the Ninth Circuit and some of the more biased jurisdictions where they don't like the Second Amendment and they don't like the Supreme Court's holdings in Heller and McDonald, have tried to twist those rulings to make it easy to uphold a gun control law, no matter how pointless or extreme that law may be, and no matter how crippling it may be for the right to keep and bear arms, individual right to keep and bear arms. So that standard of review has been basically what they've created is what's referred to as an intermediate standard, where they grant a lot of deference to the government's purported reasons for passing such a law, and then they really do everything they can to not include that law under the Second Amendment's protections. A great example of this was the public carry laws, where we've challenged and other circuits have challenged as well. The CRPA has been one of the leaders in these lawsuits with the Peruta case, challenged California's licensing scheme or lack thereof to give people the ability to carry a firearm in public. Well, the lower courts, some lower courts, and all the folks on the other side of this argument have tried to argue that the Heller and McDonald decisions were limited to the home, so that the Second Amendment doesn't protect the right to bear arms or carry arms outside of the house at all. It only protects your right to possess a firearm in the house. Well, that's ridiculous, but that's one of the things that they can try and do to take any given law outside of the scope of the protections that the Second Amendment, where the Second Amendment applies. So that debate has been working its way through the courts ever since 2010 to try and get the Supreme Court to say what the appropriate standard of review really is and to set the record straight. So what's happened now in the Cantor case, we saw where Judge Barrett applied a different type, took a different approach, took the approach that we really believe is appropriate, which is an originalism approach. And that we have 4 judges on the Supreme Court already who are adopting that approach. That's the approach that was recommended in Heller. That's the approach that Justice Scalia has championed while he was alive. And that's the approach that Judge Barrett is advocating. Well, when you do that, instead of getting into these Rube Goldberg mousetrap kind of complicated analysis of whether or not it's within the scope of the right and is it justified under rational basis or intermediate scrutiny or strict scrutiny or these other levels of complicated standards of review, you look at the text of the law, you look at the history of at the time and what people were trying to accomplish, you look at the traditions of the time, and when you do that with most gun control laws, there is no analog, no precedent, no type of law that applied back when they passed the Second Amendment that you can use as an example and say, well, the founders accepted it then, so we need to accept it now. So what she said in the Cantor case, when the individual that was trying to get his rights to own a gun back because he had lost them as the result of committing a non-violent felony, but had showed all the rehabilitative he'd proven he was rehabilitated, essentially. He hadn't been in trouble. He'd been a worthwhile member of the community. And he wanted to petition to get his rights back and said that the law that simply made anyone with any felony conviction lose their rights to own a gun forever was unconstitutionally overbroad. He applied the text, history, and tradition approach and would have held that that law was unconstitutional and that in certain instances, nonviolent felons, at least, when they prove that they're not a threat, can get their gun rights back. So it's not so much the specific issue of the individual who should have been entitled to get his gun rights back, and she was in the dissent advocating for that. It's the approach she took, the originalist approach. That approach applies in all the cases that we have going on right now. And that's what's going to make a difference in deciding the constitutionality of any gun control law.
Yeah, and that leads me into my next question about the originalist interpretation of the Constitution as a whole, and what that means for the Second Amendment. Because when you look at a case based on the historical context of the law, it does away with these arbitrary scales that many judges try to place the Second Amendment on, and it's kind of a sliding scale of where does it fit. And so how does that originalist view apply to future Second Amendment cases going forward should she be confirmed? I mean, I know you said there were other judges on the Supreme Court that actually follow that same line of reasoning, and having one more, what would that say for Second Amendment cases moving forward?
Well, the important thing is when the Supreme Court hears a case, and it doesn't really matter if it's a black rifle case or a 10-plus round magazine case, or the ammunition background challenge in the CRPA's Rhodey case, the challenge to Newsom's ammunition background check law. Once the Supreme Court says, hey, lower courts, you've been doing it wrong, you've been applying the wrong standard of review, here's the right standard of review, here's what the analytical framework that you should be applying when you're determining whether any given law is constitutional or not. Once it makes that clear, then it's basically a hard reset, because in the Ninth Circuit in particular, and most of obviously my experiences in the Ninth Circuit, in the Ninth Circuit they've been doing it wrong. So all the cases from 2010 forward that we brought in the Ninth Circuit that we may not have won, we've won some great ones lately, but even the earlier ones where the court was struggling to come up with a standard of review, and then came up with this standard of review, which really makes it difficult to overturn a law because they grant so much just deference to the government's statements and findings. That all goes out the window, and we start over and look at those laws again, now using the right standard of review and looking at whether or not the laws that California has were the kind of laws that would have been tolerated when the Second Amendment was passed. And many of them would not be. So I really look forward to the day where my 600-page gun law book, California gun law book, is down to a pamphlet, because most of the laws that they're not saving any lives, they're not making us any safer. The truth of the matter is that the government and the Sacramento Democratic machine, now led by Gavin Newsom, wants to do everything they can to eliminate gun ownership, to eradicate the gun culture, as they like to call it. I call it, the freedom-loving folks who like to be able to choose to own a gun to defend their family or for sport. But they don't want people to be able to, they want to make it as hard as possible to choose to own a gun by setting up as many regulatory hurdles as they can, by blocking guns from as many people in as many places and as many types of guns from being available as they can, so that they minimize the right to self-defense, they minimize the sport, and they minimize the political influence of gun owners.
Absolutely, and I think they know, and we know, that many of these laws would not meet the level of strict scrutiny, which is where they really should be viewed at, under a strict scrutiny
Right,
level.
because an important part of that is the government has to prove that the law actually works, that it actually accomplishes something. All of this stuff is just feel-good political theater for the most part, where politicians get to hold a press conference and say they're doing something, or they did something, and promise that you'll be safer, and you can rely on the police to defend you. Meantime, they're defunding the police. But it's about government power, the scope of government power, and I think the Second Amendment is the tip of the spear on limiting a big government overbreadth, and an overly powerful government that ultimately makes the decisions for every aspect of how you have to lead your life.
Okay, great. Well, Judge Barrett was very clear that she was a gun owner in her hearings. And what does this say to gun owners who feel that the courts create law many times instead of determining what the law says in light of the Constitution? And do you think that this could have a bearing on future Second Amendment cases going forward?
Well, she's when you say they create law, they interpret laws. Sometimes the way they interpret laws makes policy, which could be viewed as new law because it expands a law's application or restricts a law's application. Originalists do not. They try to not do that. They try not to interpret a law in a way that goes beyond what was originally intended. They try to be faithful to the language, the text of the law. That's where you get into this argument between strict constructionists, originalists, and these folks who believe in a living constitution, and they want to be able to reinterpret words in light of modern times. The problem with that is it's completely subjective and ignores the role of Congress, frankly, because if you want to change the law or expand the law, then pass one.
And I think that's exactly what Judge Barrett has said is you may not like the law, but I have to go where the law leads me in my, issuing my judgment here. And a lot of people don't like that. They want judges to create law out of thin air. So
and that's what you really saw at those confirmation hearings is people criticizing her, not because she applied the law wrong, not because she wasn't faithful to the law, but because they didn't like the ends. They didn't like the ultimate rulings. And so they want to get a judge that won't really be faithful to what the Constitution actually says, but will advance an agenda, effectively become a lawmaker / policymaker by virtue of the way they interpret existing laws, so that Congress doesn't have to do its job of passing the law that says what they think it ought to say.
So I think I know the answer to this one, but is it surprising to you that some of the Democrat senators had great difficulty discussing the specific issues with understanding kind of the legalese of some of these Second Amendment issues during the hearings when they're the ones that are trying to pass more gun control in the country all the time, and they can't even understand the cases that are before them?
Yeah, look, I mean, you're absolutely right. Remember, Hillary Clinton said that the Heller case was about keeping guns away from babies. I mean, none of them, I doubt they've read the cases. I don't know which ones are and which ones aren't lawyers, but none of them, they don't understand the application, the mechanics of how the law is read, analyzed, and judged by the judges to be constitutional or not. They just are arguing for a policy that they want to advance. It's not really law. It's policy, and they want the law to conform to their policy rather than the other way around. So yeah, and a lot of them had no idea what they were talking about.
Thank you for watching, and to Chuck Michel for his insight on these important issues. I would encourage the viewers to watch for more information on part 2 of this segment on the Supreme Court nomination process and the ongoing and future cases that CRPA currently has. If you're not a member of CRPA, you can join them at crpa.org. And as always, if you'd like to support the ongoing litigation efforts with CRPA to get some of their cases to the Supreme Court, you can donate in the link below in the comment section. Thank you.